No matter the amount of evidence, no matter the lives lost, the excessive force used, there's no way to win. Today we're going to be talking about the legal doctrine of qualified immunity and why it makes it almost impossible to prosecute a member of the US police force. The links and the sources to everything I'm discussing in this video is in the description. I encourage you to click and read and go and find out more yourself. I've also included links to Black Lives Matter donation fund pages and also petitions. I am speaking in this video from my own personal research, and so this video is a point of my own personal commentary on the situation. I have learned so much over the past week that I had no idea of beforehand, which to an extent makes sense. I'm not a US attorney. These laws can't directly affect me. But just because something doesn't directly affect you doesn't mean you shouldn't speak up about it. I'm absolutely appalled and shocked and disappointed and frustrated and angry that this legal doctrine still exists and it still works even today, even in the future until we see reform. It still gives a free card to individuals that have committed wrongdoing and will never see accountability or liability for their actions because of this legal doctrine. Education, awareness of oppressive systems, and legislative reform is what's gonna help us see change, and that's what today's video is all about. I encourage you to watch, listen, engage, share this with other people that you think maybe weren't aware or could be aware. I've also created my own petition. The petition directly addresses the US Supreme Court and asks them to look at legislative reform and change for the qualified immunity doctrine. That is linked in the description, and if you could go and sign that and share that, that would be incredible. To best explain qualified immunity, we're going to start with the case of Johnny Leija. On the 24th of March 2011, Johnny Leija was in hospital. He was sick, he was confused, he had pneumonia, he was agitated, and he was refusing to return back to his hospital room. He was in the corridors of the hospital. The hospital staff, not knowing what to do, they called police officers to come in and help them restrain Johnny. The officers shot Johnny with a stun gun. They followed him down the corridor and they then wrestled him to the floor and attempted to restrain him and put handcuffs on him. The police officers were bearing all of their weight on Johnny, and they managed to get one handcuff on when Johnny went completely limp, and he died. He passed away under the weight and excessive force from the officers. The chief medical examiner's office declared that Johnny died because of respiratory insufficiency. Essentially, he couldn't breathe. The county sheriff and the police chief defended the actions as being appropriate to the situation, and the police officers involved were not charged. Irma, Johnny's mother, took the only other route in this situation, which is that she sued. She alleged that the officers used excessive force and that this force violated her son's Fourth Amendment US Constitution rights, which protects the individual against unreasonable search and seizure. However, almost immediately, her case hit a barrier, and that barrier was the legal doctrine of qualified immunity. So let's give some context here. In limited situations in the US, if you've had a violation of your constitutional rights, you can sue. This dates all the way back to the Civil Rights Act of 1871. Congress gave Americans the right to sue public officials who violate their legal rights. In section 1983 of the US Code, Congress said that if a public official violates your rights, whether it be via police brutality, an illegal search, or an unlawful arrest, you can file a lawsuit to hold that public official financially accountable for the conduct. The language that Congress used here was unequivocal. Any state official who deprived an individual of their rights should be liable to that party. However, even if your constitutional rights have been violated, this can be blocked by the doctrine of qualified immunity. Qualified immunity dates all the way back to 1967, which ironically is the same year that a Miami police chief coined the phrase, "When the looting starts, the shooting starts." Now, in 1967, a police officer had arrested a group of black clergymen for peacefully using a whites-only waiting room in a bus terminal. When the clergymen then tried to sue the police for violation of their constitutional rights, the court ruled that the officers shouldn't face any legal liability because they had enforced the law in good faith and with probable cause. And that is what set the foundations and the legal test for qualified immunity. if an officer could persuade a court that they had acted in good faith and with probable cause, then they couldn't be liable for a violation of someone's right. Now, since 1967, the law has evolved, it's developed, and it's now been defined by the US Supreme Court. Essentially, it sets a two-limb test. So if you've been in a situation of police brutality or excessive force, you then claim and you take that to court. In part one of the test, the court will consider whether the police has used excessive force in violation of the Fourth Amendment of the US Constitution. So that part one is a relatively easy standard to meet, because if you have any kind of evidence which would show that excessive force has been used, then you probably hit part one of the test. You can probably prove that force was probably unreasonable or excessive and that you've had a violation of your civil rights. However, this then becomes a lot more problematic at part two of the test. And part two of the test is what essentially blocks all claims that are taken to court. In part two of the test, the court determines whether the police should have known that their actions violated the Constitution because court precedent clearly established their conduct as unlawful. The important words here are clearly established. Now, what does clearly established mean? Clearly established precedent means that the court has to look back at previous successful cases and they have to be able to apply the facts of those previous cases to the current case. So essentially, they are trying to match a fact pattern. They are trying to say the facts of this current case are similar to that case in 2001 where we prosecuted that policeman, and therefore we can rely on that previous case in 2001 and we can say, yes, the facts are similar, we can prosecute again. Now, the problem with clearly established precedent, and this is at the very heart of why qualified immunity doesn't work and why qualified immunity is so problematic, is that in court you can essentially allege any kind of difference between the current case at hand and a previous case. For example, the fact pattern can be almost identical, but if you can show there is one difference in facts between the current case and a previous very, very similar case, then the court can rule there is no clearly established precedent, even if that difference is incredibly minor. For example, in the past, the differences between two cases can include the distance between the man and the officer in the case. The literal, like, physical difference between the officer and the man. Even if every other fact in that situation was completely the same, the distance between the policeman and the man was slightly different in case A and case B. Therefore, there is no clearly established precedent. The cases are not similar. The judge noted that because one case occurred in a Target parking lot and the other one occurred by a roadside, even though the facts of both situations were identical, because the locations were different, there was no clearly established precedent. What is this? To be honest, every crime that occurs is going to be slightly different. There's going to be some kind of fact that is slightly different to a previous case, and therefore the cases have no clearly established precedent to ever rely on. When I was doing my research, I think it was best summarized by the Institute for Justice in the US, and they said qualified immunity means that government officials can get away with violating your rights as long as they violate them in a way that nobody had thought of before. Now, at this point, you might be in a similar situation to me, which is that you are sat there watching this and you're thinking, why on earth does this legal doctrine exist? Why is this still going on with no one questioning this? The Supreme Court is continuing to enforce this doctrine today and will continue to enforce this doctrine until there is legislative reform. So I've been doing some research, and the Supreme Court has essentially offered a number of justifications of why qualified immunity is necessary. So justification number one is that without qualified immunity, the police force would not be able to do their jobs properly, because it should be recognised, and we will recognise in this video, that the police force have a very tough job. They're in situations where their life can legitimately be at harm, and therefore the Supreme Court has argued that police officers would not be able to do their job properly if they didn't think that they had some kind of legal protection for their actions. However, psychological studies have essentially proven that wrong. Study after study has shown that law enforcement officers don't actually think about the threat of being sued when performing their duties. It is actually not psychologically in their mind associated with not therefore having legal accountability for those actions. The second justification that the Supreme Court has used is that qualified immunity protects police officers from being bankrupted by civil lawsuits. So that's the idea that if there was no qualified immunity, everyone would sue the police, and therefore the individual police officers would never be able to pay the damages that they were charged with. But that actually isn't a very good argument, as all of these arguments are not very good. But that justification essentially completely ignores the reality that police costs are never paid by the individual. They're almost always paid by the police insurance or the police unions. So if the police were suddenly faced with many civil lawsuits, it wouldn't affect the individuals, it would affect the police as an institution. And arguably that would therefore see change in the way that they train their officers and the way they think about excessive force and police brutality. So arguably that would be a good thing. So what can we do here? Where are we left in this situation? I think it's first important to realize that it is not some kind of coincidence that these cases of police brutality never lead to actual liability or enforcement or damages or compensation. The reason that they fail is because of the law, and because the law is not fit for purpose. The definition of a clearly established precedent has been narrowed so much by the Supreme Court over the past 10 years that it almost always never applies. And because of that, police officers in cases of police brutality, excessive force, are almost always never held accountable. As put by Justice Sonia Sotomayor, qualified immunity sanctions a shoot first, think later approach. That effectively completely undermines the point of constitutional protections. Because even if your constitutional rights under the US Constitution have been violated, this legal doctrine and the expansion of its application over the past 10 years has meant that it is almost impossible for a claimant to win. No matter the amount of evidence, no matter the lives lost, the excessive force used, there's no way to win. It is so important that we continue learning and educating ourselves. I had no idea any of this existed, and it is so fundamental in protecting our rights and our protections as literal human beings. Please do add to this conversation in the comments. This is just my limited commentary on the research that I've done, but I know there is so much more for me to learn, and I want to learn. Thank you so much for watching.